Good evening, everyone. Quick audio check. Before we begin, let's do a quick audio check. Please let me know if I am audible to everybody. Yes. Yes, I am. Okay, great. Great to be back again with you, all of you here, audible and invisible. Prashant is more specific. Okay, love you for that, Siddharth. Okay, so a very warm welcome to all of you here who are here. I have Sinchari, Pragati, Sindhuja, Chahat, Atika, Asta, of course, Prashant, Lalit. Okay, Upasana, great to have you guys here. And I'm sure all of you are aware आज हम क्या करने वाले हैं. As the slide right in front of you tells that today we are going to begin with the concept the concept of intellectual property right. अब ये overall एक बड़ा topic है, so it's not something that we will be able to finish in one session. And as you know, हमारा ये पूरा series चल रहा है अभी miscellaneous laws का. So those of you who missed and who are just looking at this lecture on IPR today, I would recommend that you can go onto the description box. You'll find links to the prior sessions we've had on miscellaneous law. We've covered family law in great detail. We've done, environmental law also. So if you are keen on those things, you can always go to the description box and look up those links instead, right? So far as today's session is concerned, today we are going to discuss the concept of intellectual property. Okay, I'm Neha, and we are an organization called Clat Possible, and we help students get into their dream element, right? So today we are going to start off with intellectual property, right? Okay, so let's begin. And okay, so when you talk about this entire concept of intellectual property, any kind of property would always need protection. Can you have, can you imagine having a property without any kind of protection being granted to it? That would be a very difficult proposition. Whenever we are talking about property, whether it is property which has some sort of a physical existence, like if it's your car, your house, your land, those things are your prized possession, and because you can physically touch them, feel them, they become a very important property for you. They have a lot of value, so you want a lot of protection. There are a lot of laws which deal with protection of those corporeal properties, tangible properties. But when we are looking at this concept of intellectual property, ये थोड़ा सा यहाँ पे different हो जाता है. Because whenever we are talking about IPR, whenever we are talking about intellectual property, here this property is a property which is a creation of your intellect. It's supposed to be something which has been created because of your intellect. It may not have a very, very physical manifestation per se. जब physical manifestation हो ही रहा होगा उसका, वहां पे भी it's very difficult to say कि ठीक है ये वाली property ये physically मेरी है, बाकी और मेरी नहीं है, right? So it's a very difficult proposition to have a physical manifestation of certain types of property. तो ये वाली जो category है जो कि आपकी intellect की property है, which is supposed to be intangible, you cannot touch and feel, incorporeal, which means it's not supposed to have any physical form as such, जहाँ पे आप उसको protect करके अपने पास, जैसे अगर मेरी गाड़ी है तो मैं तो उसकी चाबी लॉक करके गराज में बंद करके कवर करके रखी है. Now I feel safe that my car is safe, right? But when I talk about intellectual property, it doesn't really have the same physical form, right? That is why when we are talking about intellectual property, they are a little different, right? So, like for example, I'm sure everybody here knows exactly what the examples of intellectual property are. They're right here in front of you. There's patents, copyrights, trademarks. In fact, there are many more. And in today's session, we would be, after a brief intro on what the IPR regime is about, we are going to dwell into specifically copyrights and trademarks into this session. Okay. Okay. Now that is a brief idea कि ये intellect से related आपका property है. So it's not essential that it is a physical property. But then why do you need protection? Why is it that something like let's say patent? Can anybody briefly tell me what patents are? What do they protect? If I'm talking about patent law, what is this? What kind of property is it protecting? Patent? What kind of property are we talking about here? What is the protection being granted for? Yes, quickly in the chat box, please. Very, very basic. This is something which everybody would know. What is intellectual property? Of course. Okay, good, Lalit. Lalit is telling me it has to be an invention. Good. It could be regarding process. It could be regarding product. Yes, somebody wrote that. That is good. Invention, right? So it is an intellectual property, but we are protecting here something new, novel. Somebody mentioned here novel. It's a bola tha ye, the good word which was used, right? Yes, the novel है कुछ नया है आपने create करा है आपने invent करा है. Let's say you created a new medicine, right? Let's say you actually come up with a cure for COVID, for coronavirus. Then what are you doing? You have created, there is a new, something new which has come into the market. Now, when you are talking about invention and something new being created, that is when we are talking about the concept of patent, right? Now, here, when you look at why do we need IPR? Now, imagine a scenario where there was no protection of invention. Then, do you think that pharmaceutical companies or any research organization would be willing to pump in, crores and crores of rupees on research? अगर उनकी research को कोई protection ही नहीं मिलेगा, if there is no protection given to their research, would they ever be, driven, or would they ever put in their resources in the concept of research? No, right? They're not going to do that. It is only when they know that हमने research करा and we found something which is novel, something new, and we can actually get protection in the sense that okay, we have come up with this new drug and ये जो नई दवाई हमने medicine हमने cure हमने निकाला है, then we will be the only ones who will be able to manufacture, use, reproduce all those things and will have the exclusive use of. Right? So exclusivity का जो concept होता है, that is what drives, is the driving force behind IPR. This fact that आपका property है, आपकी exclusive usage होगी. If anybody wants to use it, then they will have to seek permission from you. Normally इसको हम IPR में license बोलते हैं. That's the technical term we use. कि अगर किसी और को use करना है, तो जो IPR holder है, उससे आपको license लेना पड़ेगा. Only then, right? So when we are looking at this entire concept of IPR, why do we need? You need because you want to have recognition. There has to be some financial benefit which are arising out of it. तभी आप जाके इतनी research करोगे, इतना effort डालोगे. अगर आपको नहीं मिल रहा, why would you ever do that, right? So that's something which is very, very essential. Now, अब ये तो एक angle है. This is one angle to look at when you're looking at it from the perspective of the guy who is actually applying for the patent or who wants protection. But a lot of times in life there has to be a balance which has to be maintained, right? So ये IPR law में balancing act भी बड़ा जरूरी होता है, क्योंकि एक तरफ है right आपके stakeholder here means the person who is applying for protection of his IPR. On the other hand is the society. Right? So आपको protection तो grant करना है, but it should not be going against the wider public interest. That is why जब आप patent या कोई और ये right IPR की बात करते हो, they don't give you an unlimited sort of a right. All these rights are generally for a fixed time period. तो कोई time period होगा आपका जब तक आप ये right, जैसे patent के लिए there is a time period, for copyright there is a time period. So that fixed time period is there beyond which you will not have any rights in that particular IPR. Or it could be like, in certain cases, your patent which has been granted to you could be taken away if there is an emergency. Those emergency provisions are also provided within the law itself, which is giving you the right, might for the sake of balance, might for the sake of welfare or wider, public interest, there could be a case where right gets restricted, right? So ये IPR में ये concept भी बहुत important होता है, right? So let's move on. That was a little bit of a basic thing on what is meant by IPRs. Hatika is saying your voice is a bit followed. Okay, sorry, my voice is a bit followed. तो मेरे थोड़ा सा गला खराब है, इसलिए तो नहीं आपको लग रहा. I hope that's not the reason. Okay, I'm glad Dinesh. चलो, अच्छा, अब ब्रीफ हिस्ट्री, राइट? अब आई नो लाइक मोस्ट ऑफ द कि मैम थ्योरी तो आएगी नहीं, बट एक थोड़ा सा बेसिक आपको हिस्ट्री अगर पता हो आईपीआर का, इट हेल्प्स बिकॉज़ योर पैसेजेस आर सच दैट you get these passages not just on the basic concept, but they take a historical view of it also sometimes, right? So when you look at the history of IPR का सबसे पहला formal जो हम बोलते हैं कि इंटरनेशनल लेवल पे कि when IPRs were recognized that intellectual property needs to be protected, that whether it's patents, trademark, industrial design, service mark, हर टाइप के इन्होंने IPR को इंक्लूड करके जो सबसे one of pioneering conventions, international conventions on this was the Paris Convention, right? So ये Paris Convention जो है ये 1883 का है. This was about all types of IPR, right? It was the first time such a convention was ever entered into, because ये if you realize जो आपके IPRs होते हैं ये domestic protection इनके लिए काफी नहीं होता. Most of the time you need international protection, right? Because अब आपने एक जगह दवाई बना ली, now you want that nobody should copy it. Now nobody should copy it, meaning that nobody in India, nobody abroad. International protection is what you are seeking. That is why what you would realize is IPR even in India. Whenever we look at our Indian laws protecting IPR, most of the time we have been amending our laws in the past 10, 15 years because of our international obligations. We have international obligations being a member of the WTO, because of WIPO, being a member of the TRIPS agreement. There's so many things because of which we are, we have been changing our law, amending our law, ensuring that we are, again at the in pace with the international scenario so far as IPR protection is concerned. So that's something which is very, very crucial. ठीक है, तो सबसे पहले आया था आपका पेरिस कन्वेंशन, फिर आया आपका बर्न कन्वेंशन. जो ये बर्न कन्वेंशन था ये ज्यादा स्पेसिफिक था. This was on literary and artistic work. So literary and artistic work है, that means which IPR are they talking about here? The Berne Convention, which is the intellectual property which gives protection of to literary and artistic work. Good, Lalit, we are talking about copyright, है ना? तो copyright है वो protection करता है आपके literary and artistic work का, right? So here the Berne Convention was about copyright. Then you had the Madrid Convention. This was on mark, basically when we talk of trademark, right? So these are some of the historically very, very important conventions which are dealing with IPRs. आज की डेट में, so far as today's times are concerned, the WIPO, that's your World Intellectual Property Organization, which is an independent United Nations agency. This is the international body which looks after the entire governance of IPR law across the globe, right? So आज की डेट में these were the historically important, and this is the organization जो कि आज की डेट में IPR के बारे में गवर्न करता है इंटरनेशनल लॉ को, ठीक है? So here of course UN का है organization, so tell me इनका हेडक्वार्टर किधर होगा? The most obvious place. Yes, tell me किधर होंगे वाइपो के हेडक्वार्टर? हाँ जी, UN के ज्यादातर headquarters का होता है. Good, Prashant. You know, it is like the most yeah, uh, sought after place so far as the UN is concerned, Geneva. है ना, वो सब कुछ वो जो है उनके हेडक्वार्टर जो है वो जिनीवा में ही बनते हैं, तो उसमें कोई रॉकेट साइंस नहीं है कि भैया वाइपो का भी उन्होंने जिनीवा में बनाया, राइट. अच्छा ठीक है. तो अब बेसिकली हम आईपीआर के अंदर क्या क्या कवर करते हैं. नॉर्मली यू हैव योर ट्रेडमार्क, copyright, trademark, patent, geographical indication, industrial design, trade secret. This is also something which is new and it is happening, and we would discuss it in detail in the next session or something. And एक और अलग चीज जो trade which generally you don't think of when you thinking of 5 years is plant protection and traditional knowledge. कई बार आप biodiversity के नाम से भी जानते हो. So that's another thing which is also included within the IPR domain. Okay? So these are the things which we would be discussing subsequently. As today we are going to start off with the concept of copyright. Right? So इससे पहले कि हम और time waste करें, let's quickly begin with the concept of copyright. Now, when we are talking of कॉपीराइट में सबसे इम्पोर्टेंट चीज क्या होती है कि भाई कॉपीराइट कवर किसको करता है, राइट. व्हाट इज इट दैट इज प्रोटेक्टेड अंडर द कॉन्सेप्ट ऑफ copyright. So when you are looking at copyright, it is talking about literary and artistic work, right? So copyright is sometimes also referred to as an author's right. Very very loosely जब हम copyright की बात करते हैं तो हम उसको author's right भी बोलते हैं. But it is much wider than that. You're generally covering, in all forms, you're covering literary and artistic work. It could be books, music, sculpture, films, cinematography, जिसको हम बोलते हैं, computer programs. This is something which was not there earlier, but the computer programs are also included. Computer databases, advertisement, maps, technical drawings, anything which has anything to do with literary and artistic work is generally covered within the domain of copyright. अच्छा, कॉपीराइट से रिलेटेड इंडिया में लॉ कौन सा है? वी हैव द 1957 का द कॉपीराइट एक्ट. दिस इज द लॉ व्हिच गवर्न्स द कॉन्सेप्ट ऑफ कॉपीराइट इन आवर कंट्री. अब ये प्रोटेक्ट क्या करता है? कॉपीराइट बोलता है कि भाई जो भी वर्क है ना, ऑल द वर्क आर प्रोटेक्टेड अंडर द कॉन्सेप्ट ऑफ कॉपीराइट. अब ये वर्क क्या क्या है? इंपॉर्टेंट चीज कि ये वर्क सबसे पहले होनी चाहिए ओरिजिनल, राइट. So whatever literary or artistic works you're talking about, they have to be original. They cannot be copied from somewhere else. ये किसी और की चीज आप अपनी बना के अगर you try to treat it as a copyright, that will not work. It always has to be something original. Original could be literary work. Literary work could be you've written anything. Now, when you are talking about literary work, always remember copyright means प्रोटेक्शन के लिए ये जरूरी नहीं है कि आपका लिटरेरी वर्क कहीं पब्लिश हुआ, राइट. सो इवन इफ इट इज नॉट पब्लिश, आपने एक बुक लिख लिया, उसका मैन्युस्क्रिप्ट आपने अपने घर में अंदर रखा हुआ है, राइट. कैन एनीबडी, somebody comes to your house, let's say your friend comes and that manuscript is kept in your room और आप वो आपका मैन्युस्क्रिप्ट लेके जाके कहीं प्रिंट करवा दो, कैन ही डू दैट? No, because once a literary artistic work is created, the moment it is created, your copyright is created over it instantaneously. Because जब हम copyright की बात कर रहे हैं, it means that you being the author have, from the moment of its creation, have the exclusive right of making copies of the thing. Nobody else can have this. Right? So जब आप literary work की बात करते हैं, a lot of times you get confused that it is essential that you have to get it published, printed somewhere. You get a right the moment it is created, right? So literary work is pretty wide. It could be anything that you've written, a paper that you've written, a book that you've written, a poem that you've written, some prose that you've written, computer programs. Those are also considered as literary work. All those would be considered as literary work. Then you're talking dramatic work, any kind of drama, any kind of dramatization, anything like that would also be considered as copyrightable work. Musical, anything which is music. Artistic work would include not only painting, sculptures, any kind of basic idea being that there has to be some sort of form which is given to it, right? So if you give some sort of a form to your idea, that is when it becomes copyrightable, right? Cinematographic film, sound recording, obviously I think everybody knows, you talk about a movie, you talk about a moving picture. तो यहाँ पे जो ये cinematographic film है, इसका मतलब ये नहीं कि आपको पूरी की पूरी picture बनानी पड़ेगी, right? So here even a shorter video which you made, but that could also be covered under the concept of cinematographic films, right? Hasika, all these subjects, right, yes, the moment they have not been published, the moment they are created, तभी आपका right उसमें create होता है. Publication वाला concept is not essential, right? You don't need to get it published or something. The moment it is created, that is when you have a right to it. Similarly, when it comes to sound recording, the moment the recording is done, that's when your right is created. Okay, so all these have to be original. That is something which is very, very important. There are some very, very important points which you need to keep in mind on copyright, because over a period of time, what we have observed, what I have observed from the past year question papers and all, ये कुछ point हैं जिनके ऊपर आपके एग्जाम में बहुत बार क्वेश्चन करते हैं. There are a lot of reasoning questions which are created on these concepts. Now, the first concept here that we are talking about is what is the time period for which your copyright is granted. So the time period is for your entire life, right? So if you're the author of a particular literary work, artistic work, or whatever, your entire life you are going to have protection, and 60 years after this, right? So both the things are going to be there, your entire life plus 60 years. So if you died, let's say in 2000, okay, so till 2060, you will get protection, which in effect also shows कि ये ऐसा property है जो कि आप inherit भी कर सकते हो, क्योंकि author तो अब is dead, तो उसके जो भी legal representatives होंगे, उसके भी legal heirs होंगे, they will actually have a right, hold a copyright for the next 60 years even after his death. In fact, India में ये 60 years है, जो हमारी इंटरनेशनल एग्रीमेंट है वर्ल्ड वाइड, नॉर्मली दे प्रोवाइड की 50 years होना चाहिए, बट इन इंडिया वी हैव एडेड +10 एंड वी हैव kept the time period as 60 years, right? So entire life plus 60 years. अच्छा, एक और कॉन्सेप्ट जिसके ऊपर अब काफी क्वेश्चन आते हैं is the concept of idea versus expression. This is something I was mentioning a little while back also, that जब आप copyright किसी चीज के लिए you are saying that I have a copyright on this, there has to be it has to be expressed in some form. A mere idea is not copyright. जैसे कई बार आपका एक बहुत फेमस PYQ टाइप का क्वेश्चन है कि दो फ्रेंड्स थे उनका, एंड दे वर हैविंग अ डिस्कशन, एंड एक फ्रेंड को आइडिया आया कि भाई मैं एक कार्टून कैरेक्टर बनाऊंगा, एंड दिस इज हाउ ही गोइंग टू लुक लाइक, गोइंग टू बी वेयरिंग येलो फ्लैश क्लोथ with this particular design and this shape, right? तो आपने स्कूल में कभी 11th 12th में बैठ के ऐसा कोई डिस्कशन करा था, right? This friend who had this idea totally forgot about it, और वो अपना क्या बोलते हैं डॉक्टर बन के एम्स में बैठ के मेडिसिन कर रहा. Whereas the other guy, he became a graphic designer and he actually created this character, and this character became superbly famous. Now, can this friend claim a copyright over this character which is being created? Because after all, it was his idea. He was the one who had told him about this entire superhero, and he was the one who had who had this brilliant idea about the clothes and the colors and everything, right? But it was merely an idea, right? So Dr. Lalit and Prashant, both of you are right. It was merely an idea. There is no expression of the same. If there is no expression of the same, then in that case, you cannot get protection under copy. That this is also popularly known as the idea versus expression dichotomy. Dichotomy is when you are talking about something just similar, but they're very different at the same time. Big difference between the two, right? So here two different categories they fall into. So idea के ऊपर आपको copyright नहीं मिलता है until unless का कोई expression हो. That expression is something important. दूसरी चीज क्या होती है जब हम कॉपीराइट के बारे में देखते हैं, दैट यहाँ पे कॉपीराइट में आपको एक बंडल ऑफ राइट मिलता है, यू गेट लॉट ऑफ राइट. इट्स नॉट जस्ट द राइट टू मेक कॉपी, बट it would also include right, like when you're talking about adaptation, when you're talking about कि भाई कोई आपने बुक लिखी है उसको आप अडेप्टेशन करके उसकी कोई मूवी बना रहे हो, या उसकी आपने कोई you made some sort of a animation out of it, or you made some copybook out of it. If you're doing anything like that, you cannot do it without taking permission from the original. तो जो ओरिजिनल ऑथर है उससे आपको परमिशन लेनी पड़ेगी. Only then can we say that can we say that you can use that particular literary work, right? तो कोई भी आपको अगर अडेप्टेशन करना है, राइट, तो यहाँ पे आप व्हाट आर यू नॉट रियली कॉपिंग डायरेक्टली, आप रिप्रोड्यूस नहीं कर रहे हो, यहाँ पे आप उसको फॉर्म चेंज कर रहे हो, आप बुक को मूवी में बना देते हो, राइट. तो अडेप्टेशन इज ऑलवेज अबाउट उसका फॉर्म चेंज कर देते हो. जब आप फॉर्म चेंज करोगे देन ऑल्सो यू नीड टू टेक परमिशन फ्रॉम द ऑथर, राइट. So this copyright would include your right to adaptation, right of reproduction, publication. Like I was saying, ये मेरा मैन्युस्क्रिप्ट है, मैंने अपने घर में रखा, मुझे नहीं छापना उसको, आई डोंट वांट टू पब्लिश इट, right? So this is my right. You cannot go ahead and publish it. My right to publication, translation, right? Communication to public, ये सारी चीजें जो हैं ये आपके कॉपीराइट में included, right? My voice is not clear still. I don't know, because I am, like, this is the normal way we have these sessions. I'm wondering if why this issue is happening. ओके, चलो ठीक है. अब ओके, ये हो गया आपका डिफरेंट फॉर्म जहाँ पे आपका कॉपीराइट इंक्लूड होता है. ओके, नेक्स्ट थिंग इज व्हेन यू टॉकिंग अबाउट कॉपीराइट इज इट इज ऑन ऑल ओरिजिनल. लाइक दिस इज समथिंग व्हिच वी डिस्कस, दैट ओरिजिनल वर्क पे ही आपका कॉपीराइट होगा और किसी चीज पे आपका कॉपीराइट नहीं होगा. तो अगर कॉपीड है, आपका ओरिजिनल आइडिया नहीं है, ओरिजिनल एक्सप्रेशन नहीं है, देन इट कैन नॉट बी देयर, राइट. इट हैज टू बी about. Okay, Lalit is asking a question. Ma'am, mere expression can we file a case in copyright infringement? Is seeking copyright protection not necessary? Now, see, when you are talking about copyright protection would be given to you if the expression is there. The moment it has been expressed in some form, your idea, चाहे वो किसी written form में हो, चाहे वो आपने कोई स्कल्पचर बनाया हो, कोई पेंटिंग बनाया हो, कोई ना कोई उसका फॉर्म होना चाहिए, तभी आपको कॉपीराइट प्रोटेक्शन मिलेगा. अगर वो फॉर्म नहीं है, then you will not get any kind of copyright protection, right? That is something which you have to keep in mind. See? Okay. Now, there are some other concepts which are very, very important when you talk of copyright law. एक concept होता है ownership and authorship. So, when you are talking about the concept of ownership and authorship, normally it is presumed that whoever is the author is going to be the owner. That's the general rule, that author is the first owner of the copyright. But इसका एक exception. The exception कहाँ होगा? When we look at the concept of works made for hire, which means that if you are either an employee who is working under the instructions of an employer, which means let's say आप किसी IT company में काम करते हो, right? And आपकी इस IT company के working के दौरान, right, during your course of employment, you have been given this job of creating a code, right? तो अब आपने क्या किया? आपने कोई कंप्यूटर प्रोग्राम जो है क्रिएट किया. अब जो ये आपने कंप्यूटर प्रोग्राम क्रिएट किया है, you might be the author of this computer program, but can you claim ownership over this computer program? Can you claim ownership over this computer program? Yes or no? You are the author and author is the first owner. But आपने कहाँ किया है? आपने किया है कोर्स ऑफ एम्प्लॉयमेंट के बीच. यहाँ पे अब आज आता है कॉन्सेप्ट वर्क मेड फॉर हायर का. Now, since this was a work which was made for hire, therefore, even though you might be the author, you are not going to be the owner of this copyright, right? क्योंकि आपने एक काम किया ही अपने employer के लिए. So the employer is the one, or the company who is employing you here, the IT company, they are the ones who are going to have a copyright, right? तो ये कई बार आप इसको work for hire में employer employee की तरफ से भी देख सकते हो. Sometimes the word might be that you're doing it under a contract, right? So you're not really an employee, but you're working on a contract basis. And किसी contract के अंदर आप किसी और के लिए कुछ work करके दे रहे हो, then again you will not have ownership, right? These authorship might be there, but the ownership वाला concept है वो यहाँ पे missing हो जाएगा, right? But of course, unless it says there is a contract to the contrary, so you might be an employee of a particular company, but अगर आपके जो terms of employment है, उसमें ये दिया है that भाई आप बना के कोड कंपनी को दोगे, but जो copyright है वो फिर भी आपके पास रहेगा. There can be a case, this is something which is not that you cannot do it. If the company agrees and they feel that yes, you are so good, they really need you, and they let you have the copyright, then that can actually happen, right? So ये जो है ये एक exception to the exception carve out हो सकता है, right? But generally जब हम बात करते हैं कि अगर आप किसी employer under employment काम कर रहे हो, then in that case the ownership or the copyright is going to be with the employer or the company that you are working for. ठीक, तो यहाँ पे एक ये ownership versus authorship वाला concept आता है. अच्छा, somebody here, ललित पूछ रहा था, ma'am, if before seeking protection somebody infringes, can we file a case for copyright infringement? भाई जब हम copyright infringement की बात करते हैं, एक चीज बहुत 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 इम्पोर्टेंट कि भाई ये जो registration है ये compulsory नहीं, it is not mandatory, right? That means if you want, you can get your copyright registered. If you do not want to get your copyright registered, it is not something which is essential for getting protection. तो अगर आपने copyright अपना register नहीं करा है, तब भी आपका जो protection है under the Copyright Act, आपको वो protection फिर भी मिलेगा, right? It is something which is optional. But obviously, अगर आपने register करा हुआ है under the Copyright Act, then it is always better, because फिर क्या है ना, there is a prima facie proof. The prima facie proof means कि आपको अगर आप infringement का केस फाइल करते हो कि भाई मेरा copyright infringe कर रहा है कोई, तो आपको यहाँ पे ये प्रूव नहीं करना पड़ेगा कि copyright मेरा है, because there will be sort of a initial presumption that अगर registered है तो फिर आपकी का copyright है, right? On the other hand, if it is not registered, then first you'll have to prove भाई ये मेरा copyright इस पे exist करता है, and the next step would be proving the infringement, right? तो आपको दो स्टेप करने पड़ेंगे, पहले आपको प्रूव करना पड़ेगा कि मेरा कॉपीराइट है, फिर आप नेक्स्ट स्टेप जाओगे कि हाँ इन्फ्रिंजमेंट हुआ. ऑन दी अदर हैंड अगर आपको ऑलरेडी रजिस्टर्ड है तो वहां पे वो एक प्रिजम्पशन हो जाएगी कि यस दिस इज लॉजिकल, राइट? सो दैट इज व्हाई रजिस्ट्रेशन ऑफ द कॉपीराइट इज एसेंशियल. अदरवाइज द मोमेंट यू क्रिएट समथिंग, आपको ऑटोमेटिकली उस पर कॉपीराइट जो है वो क्रिएट हो जाता है, ठीक है? इसीलिए ठीक, चलो गुड, I'm glad that your doubt is clear, Lalit. So move on. Now, next thing when you're talking about copyright is what are the rights of the ownership. When we just discussed them in a little bit of this thing a bit back also, when you're talking about what is essential in what are the rights which are included when you're looking at ownership, right? So ownership में आपको रिप्रोडक्शन का है, दैट मीन्स आप कॉपीज बना सकते हो, सब्सटैंशियल कॉपीज बना सकते हो. अगर किसी और को कॉपीज बनानी है आपके काम की, देन दे विल हैव टू टेक परमिशन, राइट? यू आर सपोज्ड टू हैव द एक्सक्लूसिव राइट ऑफ डूइंग दिस. तो आपको अगर ये somebody wants to make copies of something, they will have to take permission from you. Similarly, एक कॉन्सेप्ट आता है कम्युनिकेशन ऑफ वर्क टू द पब्लिक, राइट? तो अगर आपका वर्क है, आपने कोई पिक्चर बनाया, right? तो वो पिक्चर पब्लिक में रिलीज करनी है, कहाँ पे आपने दिखानी है, ये आपका राइट है. मतलब इसमें ये पहले केबल ऑपरेटर्स वाला बड़ा कंट्रोवर्सी चल रहा था. आजकल तो क्या केबल का जमाना नहीं रहा, बट एट द टाइम जब घर में जो चैनल दूरदर्शन के अलावा अगर किसी को देखना है तो आप केबल लगाते हैं. And what would the cable operators also have? They would also have this one extra channel of their own, है ना? And उस extra channel में वो कभी कभी पिक्चर लगा देते हैं. And they would in fact even ask for money कि अगर तुम्हें ये वाली पिक्चर देखनी है, then this extra amount of money which you can give and you can look at this, you can view this movie on this particular channel. तो ये कंट्रोवर्सी हुई थी कि भाई ये जो केबल ऑपरेटर्स थे ये अपने आप इन अ वे ब्रॉडकास्ट कर रहे थे और रादर कम्युनिकेशन हो रहा था वर्क का टू लॉट ऑफ पीपल, राइट? सो हियर इफ this particular cable operator is not taking permission from the from the maker of that cinematographic film, वो पिक्चर का जो प्रोड्यूसर है, प्रोडक्शन हाउस है, अगर आपने उससे परमिशन नहीं ली है, then this would amount to an infringement of the copyright. अच्छा, इसमें एक और ट्विस्ट क्या आता है कि ये जो पिक्चरें थी, मान लो ये रात को 2 बजे लगाता था एंड नॉर्मली कोई भी देखता ही नहीं. तो उसने कोई 2-3 मूवी, एक मूवी कोई 2-3 बार लगाई होगी, बट nobody ever saw this movie. Can he still be held liable for copyright infringement? Can he still be held liable for copyright infringement? किसी और ने देखा ही, nobody heard and nobody saw. Yeah. Right? Because what is important is that right to communicate. राइट, वो राइट टू कम्युनिकेट इंपॉर्टेंट है. उसके बाद किसी ने देखा, किसी ने नहीं देखा, दैट इज कंप्लीटली इररिलेवेंट. राइट, व्हाट इज इंपॉर्टेंट इज दैट यू हैव इन्फ्रिंज्ड द राइट ऑफ द कॉपीराइट होल्डर ऑफ कम्युनिकेटिंग. राइट. थर्ड इज अडेप्टेशन. अडेप्टेशन जो हमने अभी डिस्कस किया था, अभी आप कन्वर्ट कर रहे हो लिटरेरी वर्क को किसी और फॉर्म में. बेसिकली एक फॉर्म में आपका वर्क है, अडेप्टेशन वुड मीन यू आर चेंजिंग द फॉर्म. अगर आपने बुक को मे बी कोई महंगा कॉमिक में कन्वर्ट कर दिया, वो भी अडेप्टेशन होगा. आपने किसी बुक को मूवी में कन्वर्ट कर दिया, ऑब्वियसली वो भी अडेप्टेशन. ऑफ द मोस्ट कॉमन फॉर्म ऑफ अडेप्टेशन दैट वी ऑलवेज कम अक्रॉस. अच्छी अच्छी बुक का जब मूवी बना के वो बिल्कुल literally I would say I'm not a big fan of generally the books becoming movies except for maybe Lord of the Rings. They did a really good job. Like the books are also good, but then the movie was great, right? एनीवे, तो ये हो गया आपका अडेप्टेशन. इसके लिए भी आपको ओनर से परमिशन देना पड़ेगा. दिस इज अ राइट व्हिच यू हैव एज अ ओनर. ठीक. अच्छा, अब कॉपीराइट. अब मान लो हमने बोला कि कॉपीराइट में रजिस्ट्रेशन जरूरी नहीं है, तो चाहे आपका रजिस्टर्ड है चाहे ना रजिस्टर्ड है, इफ इंफ्रिंजमेंट हैपेंस, somebody violates your copyright, then what are the remedies that you can take? Now under the Copyright Act you get civil remedies as well as criminal. तो दोनों टाइप के रेमेडीज आपको मिलते हैं. जब हम सिविल रेमेडीज देखते हैं, सिविल रेमेडीज वुड इंक्लूड एन इंजंक्शन. नाउ इंजंक्शन is generally, I think all of you would know, injunction is generally an order given by the court to stop doing something or doing something. Right. Now, vis-a-vis IPR, there are these couple of types of injunctions which are very popular. Let's just have a brief understanding कि ये कुछ जो popular type के injunctions हैं, ये कौन से होते हैं, especially when we are talking about IPR. तो सबसे पहला यहाँ पे जो पॉपुलर टाइप का इंजंक्शन है, दैट इज योर मारेवा इंजंक्शन. राइट. दिस मारेवा इंजंक्शन इज जनरली आल्सो नोन एज अ फ्रीजिंग ऑर्डर. अब ये किस टाइप का इंजंक्शन है? इंटरलॉक्यूटरी. इंटरलॉक्यूटरी मतलब टेम्पररी इंजंक्शन है कि जब आपका केस कोर्ट में चल रहा है. So right now the case is going on in the court. So the matter is pending, and while the matter is pending, during the pendency of the matter, you are getting this relief. That is why it is known as an interlocutory order. ठीक. तो अब ये जो इंटरलॉक्यूटरी ऑर्डर या टेम्पररी जो आपको ऑर्डर मिला है, ये किस चीज के लिए है? दिस इज टू फ्रीज द असेट्स. Now what are you going to do? You are basically going to freeze the assets of the dependent company. When you are freezing the assets, what you are basically doing is you are safeguarding the interest of the people. Because ऐसा नहीं होना चाहिए कि by the time case end हुआ तब तक आपको रिलीफ मिलना चाहिए and the person had this money, पर वो सारा पैसा जो है अपना यहाँ वहाँ करके गायब कर चुका है. Right. So this is basically in order to ensure that the interest of the plaintiff is safeguarded. So बोलते हैं becoming judgment proof. ये ऐसा नहीं होना चाहिए कि जो आपका डिपेंडेंट है वो जजमेंट प्रूफ हो जाए, मीनिंग देयर है कि इसका पैसे नहीं बचेगा तो आप इन्फ्रिंजमेंट का केस फाइल करके यू वोंट रियली बी एबल टू गेट एनीथिंग. So that is your Mareva injunction. Next is when you talk about the Atten filler. अभी Atten filler order again interlocutory order है. ये basically बात करता है search and seizure. Right? This is talking about the concept of search and seizure. Right? Normally जब हम search and seizure सोचते हैं हमें पुलिस की याद आती है, बट यहाँ पे IPR वाले में search and seizure का ना एक एकदम सरप्राइज एलिमेंट होता है. तो इसीलिए नॉर्मली ये ऑर्डर भी क्या करते हैं लोग एक्स पार्टे ले लेते हैं. एक्स पार्टे क्या होता है? एनीबडी नोज एक्स पार्टी क्या होता है? कि भाई दूसरी पार्टी को एकदम सरप्राइज हो जाए, उसको पता ही ना चले. So you're sitting in your house and all of a sudden there's a knock on the door and there's this entire with the search and seizure order. You come and ताकि आपने जो जितना मेरा कॉपीराइट मटेरियल जो है आपने अपने घर में छुपा छुपा के रखा था, इंफ्रिंजमेंट का जो एविडेंस था, सब कुछ था, आई कैन क्विकली have control over that. So if I want that surprise element, I want the order to be ex parte. So ex parte क्या हो गया? One-sided. One-sided means only one party was present at the court, in the court when the decision was given. So normally जब भी decision कोई देता है court, both the parties are present. है ना? दोनों parties present होंगी तभी दोनों side की कहानी सुन के the judgment of the order is given. But ex parte order is कि एक पार्टी की बात सुन के ही कोर्ट ने ऑर्डर दे दिया, the other party is not aware of the fact that the order passed. राइट, तभी वो सरप्राइज एलिमेंट रहता है, तभी वो सर्च एंड सीजर का कोई फायदा होता है. राइट, सो व्हेन यू आर हैविंग when you are applying for an order like this or you get a relief like this, that is known as an action filler order. ठीक, तो ये very specific IPR में ये काफी यूज होता है, चाहे आप कॉपीराइट की बात करो चाहे आप ट्रेडमार्क की बात करो, वहां पे भी काफी यूज होती है. सिमिलर टू दैट इज योर जॉन डो ऑर्डर. जॉन डो ऑर्डर अगेन सरप्राइज एलिमेंट कई बार इसमें होता है. दिस is a right or this is a relief which you seek even before infringement has happened. नॉर्मली आप कोर्ट में कब जाते हैं? जब आप बोलते हैं कि मेरा कॉपीराइट ऑलरेडी इंफ्रिंज हो चुका है. बट जब आप जॉन डो ऑर्डर की बात कर रहे हो, यहाँ पे टाइप ऑफ प्री इंफ्रिंजमेंट रहेगी. दैट मींस इंफ्रिंजमेंट अभी हुआ नहीं है, बट यू आर एप्रीहेंडिंग कि भाई इंफ्रिंजमेंट होगा. एंड अनदर वेरी वेरी अमेजिंग थिंग अबाउट दिस इज कि हमें डिपेंडेंट जो है अननोन है. तो आपको एग्जैक्टली नहीं पता दैट 1 2 3 दीज पीपल आर द वंस जिन्होंने मेरा कॉपीराइट इंफ्रिंज करना है, बट यू फियर कि कॉपीराइट आपका इंफ्रिंज होगा. तो यू गेट दिस ऑर्डर. इट्स सपोज्ड टू बी लाइक अननोन पीपल, अनोनिमस लोगों के खिलाफ आप ये ऑर्डर ले. राइट, सो दिस इज नोन एज द जॉन डो ऑर्डर. अगेन वेरी वेरी पॉपुलर सो फार एज द IPR इज concerned. ठीक, तो ये आपका दीज आर द थ्री वेरी specific kinds of remedies which you get under IPR, right? Okay, so yes, Supriya, you're right, as a precaution. Now, this is something which is pre-infringement, which means as a precaution you are doing, right? Okay, now these were your injunctions, and all these three which we spoke about specifically were your interlocutory injunction. Injunction, of course, perpetual bhi hota hai. Perpetual is when you're talking about a permanent sort of injunction, right? वो भी court end of the day जब judgment देगी तब grant कर सकती है. The other relief when you talk under civil law is going to be pecuniary remedy. You get compensation, account for profit, as in if there is any kind of profit with the other party you see has made because of the fact that he has infringed your trademark, आपका trade for your copyright, आपके copyright का फायदा उठाके उसने कुछ profit अपना create किया है, then you can claim that also along with compensation. Because compensation is for the harm which you have suffered, and account for profit is not the harm you have suffered. Account for profit is the profit that guy has made because of infringing your copyright, right? So you will not only get compensation, you will also take back all the profit which he has made. Like आपने कोई book, आपका manuscript था, आपके घर से चोरी करके ले गया, got it print published, and made so much of profit in royalties. So not only will you ask for compensation, you will also ask for those royalties, right? So both the things are going to be asked for when you're looking at pecuniary remedy, right? Pecuniary, I'm sure all of you are aware, हम बात कर रहे हैं monetary, ठीक है, money wise जो आपको रेमेडी है, पैसे की हम बात कर रहे हैं यहाँ पे जब हम pecuniary remedy की बात कर रहे हैं. ठीक, तो तो ये इंजंक्शन हो सकता है सिविल रेमेडी में, या फिर आपका पिक्यूलरी रेमेडी हो सकता है। अच्छा, जब आप कॉपीराइट इंफ्रिंजमेंट की बात करते हो तो नॉट ओनली डू यू गेट सिविल रेमेडी, यू ऑल्सो गेट क्रिमिनल रेमेडी, राइट। तो क्रिमिनल रेमेडीज भी आपको मिलते हैं। इसीलिए जब हम लॉ पढ़ना शुरू करते हैं, हम बोलते हैं क्रिमिनल लॉ ये है, सिविल लॉ ये है, एंड ऑल दैट, बट स्लोली एंड स्टेडीली व्हेन यू स्टार्ट getting more in-depth knowledge of the various laws and how they function, you realize कि एक ही लॉ में, जैसे ये कॉपीराइट एक्ट के अंदर आपको सिविल रेमेडी भी मिलता है और आपको क्रिमिनल रेमेडी मिलता है, राइट। तो अगर आपको लग रहा है कि आपको more than compensation, what you want is the other guy should go behind the bars, he should be paying some fine, then in that case you will seek criminal remedy. और जब आप criminal remedy की बात कर रहे हो, then criminal remedy could be in terms of imprisonment. So when you talk about imprisonment, it says it should not be less than 6 months, but it may extend to 3 years. तो ये दोनों चीज हो सकती है। दिस इज द मिनिमम, राइट। तो ये 6 मंथ से लेके 3 years की बात कर रहे हैं। तो मिनिमम इतना है, मैक्सिमम इतना है। Then it could be in terms of fine, where it should not be less than 50,000 and 2 lakh. Extendable, that means again आप 50,000 to 2 lakh, इसके बीच में वाला आपको अमाउंट जो है कोर्ट का डिस्क्रिप्शन है। कोर्ट विल डिसाइड डिपेंडिंग ऑन द फैक्ट्स ऑफ द केस व्हाट शुड बी दी फाइन। सिमिलरली पनिशमेंट भी कोर्ट का डिस्क्रिप्शन है, डिपेंडिंग ऑन द फैक्ट्स ऑफ द केस कोर्ट विल डिसाइड कितना पनिशमेंट आपको यहाँ मिलना चाहिए, राइट। देन अनदर रेमेडी व्हिच यू हैव इज प्रोसीजर, जो भी इंफ्रिंजिंग कॉपीज थी, आप कॉपीराइट वाला इंफ्रिंजमेंट हो रहा था, अगर इंफ्रिंजिंग कॉपीज हैं द कोर्ट कैन पास एन ऑर्डर दैट दे शुड ऑल बी सीज्ड, दे शुड बी टेकन ओवर बाय द पुलिस एंड दे शुड बी डिलीवर्ड टू द ओनर। तो पहले आप सीज करोगे, सीज करने के बाद आप उसको ओनर को डिलीवर कर दोगे। बोथ द थिंग्स आर रेमेडीज अवेलेबल अंडर क्रिमिनल लॉ। अच्छा, एक स्पेशल चीज और क्या बोली है कि भाई अगर आप रिपीट ऑफेंडर, आपने इतना इतना दे दिया, फाइन वाइन दे दिया, उसके बाद still you are feeling कि ठीक है चलेगा, we do it one more. If you are a repeat offender, then subsequent punishment में आपका जो penalty है वो enhance हो जाता है, that means that is increase. तो आपका जो penalty है that gets increase. तो यहाँ minimum जो है 1 year हो जाएगा instead of 6 months, maximum उतना ही रहता है 2 years, but the minimum increases. Similarly, fine के मामले में भी the minimum will increase, that is going to be 1 lakh now instead of 50,000. Otherwise, it becomes maximum आपका वही 2 lakh होगा, ठीक। So these are your basic remedies under the copyright law, ठीक। अब before we end, एक लास्ट चीज कॉन्सेप्ट होता है कॉपीराइट का, जो कि एक्सेप्शन, राइट। So when you are looking at the exception to copyright, ये है कॉन्सेप्ट आपका फेयर डीलिंग। जो फेयर डीलिंग वाला कॉन्सेप्ट है, ये बात करता है दैट इवन दो टेक्निकली ऐसा लग रहा है कि आपने कॉपीराइट इन्फ्रिंज करा है, पर फिर भी कोर्ट जो है आपको इन्फ्रिंजमेंट के लिए लायबल है। व्हाई? बिकॉज हियर if you are using, fair dealing is something that is given within the act itself, कि अगर आप जो मटेरियल है वो रिसर्च के लिए यूज कर रहे, प्राइवेट स्टडी के लिए यूज कर रहे, एजुकेशन, रिव्यू, criticism, news reporting, if you are using the copyright material for any of these purposes, then it will not be considered as a copyright infringement. Of course, provided whatever you are doing is fair. Fair मतलब कि आपको कोई malice नहीं है, कोई आपका ill intention नहीं है, आपका कोई commercial purpose यहाँ पे अचीव नहीं हुआ, right? तो commercial purpose नहीं है, fair है, malice नहीं है, then in that case you can use this material, and though it might technically lead to or mean or result in a copyright infringement. तो ये आपका exception होता है fair dealing का, ठीक। I hope everybody is clear till here. So far so good. In fact, I'm just looking at the watch. It's supposed to have a 1 hour session, and it's already 8, right? So if anybody has any doubts on what we've done till now, I can take them up. I was thinking we'll do trademarks, but then we can have it in the next session. This was the basic idea behind your basic concept. And see, what is important very, very important when you are preparing for your miscellaneous laws is that there will be a lot of things to study. Like copyright के जो हमने आज cover किया है, these are the basic important parts of copyright. Now the act of course is infinite. You know, it's like a huge act. There's so many concepts under the act. But the reason why you need to attend sessions like this is you need to know that what is important. You know, you can't really start studying copyright law in and out. That is not what is required because whenever you are preparing for a competitive exam, especially like Clat, what you need to indulge in is smart study, right? You have to study smart. You cannot study like just randomly picking whatever you get and just going through. You have to be very, very picky. You have to be very, very particular because of the fact there's not much time left. The exams are around the corner. And otherwise also, you know, there will be so many other things to study. So you can't go on a random rampage and study everything across the board on copyright or on any other SPR, right? So therefore, be very precise, be very particular as to what you are learning on these miscellaneous laws also. Or in fact, anything, you know, I have heard students who come and tell me that, ma'am, should I buy the IPC का bare act और मुझे उसके sections learn करने नहीं चाहिए क्या? You know, you do not study or prepare for class like that. You've got to be a little smart, see what is relevant, and you use your space and your time accordingly for that. Okay? Then this was so far as a brief intro on IPRs and copyright was concerned. Next session that we have on your IPR laws, we are going to deal with trademarks, we are going to deal with patents, we will deal with geographical indications, right? That is going to be in your next session, next Thursday, right? So it's a Thursday to Thursday. Those of you who are new to the channel, who have not been here, are attending this session for the first time. We are doing this entire thing on miscellaneous laws, like I told you right in the beginning. And the next session, we will have a continuation of this. We are going to continue with intellectual property rights. We will start off with straight away. Next session, straight away, we're going to start off with trademark. Okay? So then, I hope you've got your notes in place. That's something which is very, very essential. Okay, then. Thank you so much, everybody. Take care. Goodbye. Have a great evening ahead, everyone.